So this bill, I don't believe, is about public safety. I think it's about punishment first and our constitutional rights last. Since the United States Supreme Court's Bruen decision, the law is clear. The government may not treat the Second Amendment as a second-class right. Restrictions must be rooted in the nation's historical tradition, not modern fear and not hostility of this body, and certainly not creative lawyering, and that's what we see. The bill escalates criminal penalties based solely on firearm possession, even for individuals who are lawfully permitted to carry. It creates a presumption of guilt. It flips mens rea on its head, and it does it in places that the state itself admits are still being actively litigated as so-called, quote, sensitive places. Let's be honest about the pattern and about the person who's driving it. Attorney General Matthew Platkin has chosen an aggressive strategy of legislating through enforcement. Rather than waiting for the courts to resolve the constitutional limits of the state's post-Bruen framework, his office continues to push bills like this one, expanding penalties, expanding presumptions, expanding prosecutorial leverage, while the legality of the underlying scheme is unresolved. And New Jersey rushed through an extreme post-Bruen response. Parts of it were blocked, then parts of it were revived, and now the core sensitive places framework, the very foundation that this bill relies on, is back in federal court again under en banc review by the Third Circuit. This matters. An en banc review is not a victory lap here for the majority, it's a warning sign. It means the court itself believes the constitutional questions are serious, unresolved, and they're far from settled, and we see it again in this bill. Our Attorney General continues to act as though this matter is closed, asking this legislature to increase criminal exposure today for conduct that may be ruled unconstitutional tomorrow. This bill assumes that possession equals criminal intent, that law-abiding citizens should bear felony exposure for technical trespass violations, while violent offenders continue to receive plea deals and downgraded charges across the state. Under this very bill before us, a person can face years in prison, not because they threatened anyone, not because they harmed anyone or intended wrongdoing, but because Attorney General Matthew Platkin's theory of enforcement later decides they, quote, should have known better. This is not historical tradition, not due process, and it sure isn't justice. Bruen explicitly rejected this kind of interest balancing. The government does not get to say, we think this is safer, and then criminalize constitutionally protected conduct by inference and presumption. Our Attorney General knows this. This bill asks the legislature to double down anyway as the courts wrestle with this. I will not vote to expand felony exposure while the constitutionality of the underlying framework this bill depends on is still before the courts. I certainly won't vote to punish the permitted, the compliant, and the lawful because Attorney General Matt Platkin refuses to respect limits on state power. Public safety does not require constitutional shortcuts, and New Jersey and this body needs to stop pretending it does. Thank you, Mr. Speaker.